He was a very caring young man. He was the baby. It was great because I could spend a lot of time with him. We were very close. And the doctor looked at him and sewed his head up. And the doctor said, you'll be okay. You're going to have a headache. Here's a prescription. You can get some medication for your headache. When he went home, his friend said he lay down on the couch and he got up to go to the bathroom and he never made it. He had a fracture of the skull and that he was bleeding internally. But it was like after the third night that they took us in a room and explained that there really wasn't anything further that could be done.
Well, the most important thing in California, and I've been doing this since 1979, representing people in medical malpractice cases, is to understand that there's a law in California that's very restrictive in medical malpractice cases. It was passed back in 1975. It's called the MICRA law, and what it does is it favors the hospitals and the doctors over the injured victims of doctors and hospitals. One of the most important things about this law is that whereas in most injury cases in California you have 2 years to bring a lawsuit, in a medical malpractice case you only have 1 year from the date that you are injured or that the injury is discovered, and you have 3 years no matter what. So if you are injured and you wait too long before you file a lawsuit, you cannot recover any damages, no matter how horrendous your injuries are. That's the first part of this law. The second part of this law is that your pain and suffering damages are limited to only $250,000. No matter how terrible the injury is, no matter if it's a lifelong injury in which you have to be bedridden or have round-the-clock care, you are limited to $250,000 for the pain and suffering and disability you have for your entire life. You can recover for your economic losses, such as your loss of earnings or your medical bills, but for your pain and suffering it's only $250,000, and this was passed back in 1975. There is no adjustment for cost of living, so it's never gone up, even though inflation has gone up many times. The recovery of $250,000 is limited. What this means is the attorneys such as myself who takes this type of case have to make sure that the case is a strong one and that we are assured of recovering the $250,000 or more if there's economic damages, because our financial investment is so high. We do not ask our client to give us any money up front. We do not recover anything from the client for costs, which can be anywhere from $50,000 to $100,000 or more in these cases, and we do not ask for any fees unless we recover for them. So we have to make sure that it is a strong case, and even though the studies have shown that there are numerous cases of malpractice, and it's one of the biggest reasons why people die in hospitals in the United States is because of negligence by some healthcare professional. Even though it is a horrendous case as far as the injury goes, if we cannot prove that the doctor or the hospital represented or treated the person below the standard of care, which is very difficult to do, then we cannot recover anything in those cases. But that being said, I have represented numerous clients for wrongful death, for surgeries that were botched, for many other kinds of malpractice. So I am experienced in those cases. Most doctors are competent. They do a great service to society. The same with most hospitals. But you have such a brief period of time, this 1 year window. In most cases, there are some exceptions, but in most cases you only have 1 year. And the sooner the client becomes suspicious or their family becomes suspicious that something is not right, that something was done incorrectly, they should come to us. And often what happens is the client or the family member will take the plaintiff to another doctor, and the doctor will make a comment offhand such as, "This should have never happened." And that is a flag sign that should go up in the family's or the client's head that maybe there was malpractice here. So they should try to come to an attorney who is experienced in medical malpractice cases as soon as possible. They should also try to get all of the records together from the hospital or from the doctor before they come to the attorney, because the attorney cannot evaluate the case unless he has all of the records in front of him, and he cannot take those records to another expert doctor to take a look at them and evaluate the case unless he has everything that is needed to evaluate the case. Under California and federal law, a person has a right of privacy to their medical records, but they also have a right to get copies of those records upon demand. So if a hospital or a doctor is telling the client, the patient, that they have to wait to get the records for an inordinate amount of time, or that the records are not available, or that an attorney should request them, this is totally incorrect. The patient has a right to those records free from the doctor or the hospital, and they should not take no for an answer. I think in most cases, unless the records are kept off-site, they should be given to them almost immediately, or if not, then within a week or 10 days. They should keep the records in their office at least for a year or so. Most hospitals and doctors do before they reduce them to film or computer discs and take them off-site. So they should be available within a reasonable period of time. If it's taking them 2, 3 weeks, 30 days, there may be something wrong, which I have seen in the past, where I've seen doctors change records even after a surgery or during a surgery. The records are changed, which is, in one case in particular, we had a death case where the doctor was doing a gallbladder surgery. He got the consent of the client to only do it through a laparoscope, which is a device that's minimally invasive. They put small holes in the abdomen, and during the procedure he determined that he needed to do it with an open procedure to open the person up. He did not have their consent to do that. Instead of just sewing him up and getting his consent, or doing it and saying that it was an emergency situation, he actually changed the records to make them reflect that he could do it as an open procedure, and he had a nurse initial them and put a time down. Unfortunately, the doctor was quite foolish, because the time that was put down was a time that the anesthesia record showed that the client was under anesthesia, and there's no way he could have given a consent witnessed by a nurse while he's under anesthesia. Needless to say, after the deposition, because I was taking the deposition of the doctor, when I got back to my office, I found a fax offer from the doctor's insurance company. Before that, they weren't offering any money. So those things can happen. So that being said, it's the best thing is to make sure you get your records as soon as possible before something can be done that is not forthright.